Hi, I'm Tom Bradford, and in this video I'm going to show you how to fulfill the financial requirements for an Innovator visa. Now, the easiest way to do this is to have already invested your 50,000 into your business in the UK, or to have had the funds transferred to a UK regulated bank. But I've prepared this diagram just to talk you through all the different possibilities. I appreciate that many of you will have your funds abroad and be ready to be transferred once you're endorsed by an endorsing body. That's fine, but I want to highlight a few things that you should avoid and basically how to go about this. So I'm going to talk these through one by one. Let's make a start. So this is all about the Innovator visa and how to show the 50,000. In this series and in the videos I've got coming up, I'm going to go into more details on the different requirements you have to meet. So the first way of showing that you meet the requirements is if you are securing the funds from a UK organisation employing 10 or more people. Now, this is probably going to be rare, but some of you will have the funds in the UK. As I said, this is possibly the easiest way of demonstrating that they are available. This sort of situation would apply. I've just got the relevant extract from the rules here. This would apply where, for example, you're getting a grant, and that may be rare, but in that sort of situation, or if the endorsing body is providing funds for you, making funds available. If the rules say any of the funds are available from a UK organisation which employs at least 10 people, the applicant must provide a letter from the organisation confirming this, and that letter must include a number of things. I've just drawn a timeline here to show you how this works. It's got to include a signed declaration from the funding provider dated no earlier than 3 months before the date of the application, setting out how they know you, the amount of funding they're making available to you, and confirmation that this funding hasn't been promised to anyone else. So this isn't really going to apply to a situation where the funds are in a bank. A bank isn't really going to be confirming that sort of thing. But if there's a third party in the UK, such as the endorsing body itself that's making the funds available, then they can confirm that. Or if it was a government grant, or say venture capital being made available. Now, this number 2 is possibly a more common one. This is a live stream, so I'm just going to reverse a bit. Bear with me. So this is overseas. This is an overseas source of the funds, or an individual. Now, in this situation, I've just done another timeline here. The rules say if any of the funds are made available from an overseas organisation, a UK organisation which employs less than 10 people, or an individual person. So in the most obvious example, this could be a family member, for example, if the funds are being made available by a family member, which is permitted under the rules. Then this is what you have to show. So I've just drawn this out here. So what you've got to have is a signed declaration from the funding provider dated no earlier than 3 months before the date of your application. And it's got to set out, again, how they know you, the amount of funding they're making available to you, and confirmation that it hasn't been promised to someone else. Now, again, this isn't something you can ask a bank to provide. This is going to be an individual or another business that's making the funds available to you. So those are the details they've got to provide. Plus, what you need here is a letter from a legal representative confirming that the declaration is a genuine one, the signature is genuine, and a bank letter confirming the funds are held in the regulated financial institution. So this would be the bank letter from the third party's bank, and it's got to be dated no earlier than 1 month before the date of the application. And if they're outside of the UK, the letter must also confirm that those funds are transferable to the UK. Now, that is a statement which, from my experience, few banks are willing to provide. In other words, a confirmation that the funds are transferable to the UK. It does depend on the bank, Remember that the bank has to be one that's recognised by the UK government, by the Home Office. But some banks are reluctant to make any sorts of statements beyond the bank statements itself. So you need to have a think about that first. So we're going to go on to looking at the most easy way of demonstrating that the funds are available. So I've just done a quick diagram here before we move on. Let me just move back to that part of the diagram we were on. So this is just my diagram showing what the letter has to show. You can see that here. The requirement for a legal representative. And my timeline just showing that letter's got to be 1 month before the date of the application. So here we are, number 3. So this is this is the scenario where the funds are held by you. So this in theory is the most straightforward. If any of the funds, the rules say, if any of the funds are held by the applicant, they must provide either of the following. So bank statements showing the funds are held in the UK by an institution regulated by the FCA. They've got to cover 3 months, ending no earlier than 1 month before the date of the application. So you can see from my diagram here, 3 months ending no earlier than 1 month before the date of the application. If these documents do not show the applicant has held the funds for at least 3 months, the applicant must also provide a signed declaration and letter from a legal representative as set out above. So that was the rule that I just illustrated. Now, I think the key issue here is if you have the funds but you haven't had them for 3 months, then the question is, should you wait or should you provide the evidence that's required by the previous rule? In other words, securing a declaration plus from a third party plus the legal representative and plus the bank letter. Now, the difficulty with that is if they're held by you in a bank, but it's been for less than 3 months, I find it difficult to believe that any bank will provide the third party letter in the terms set out under the rules. And there's a reason for that. That letter confirms things like they haven't been promised to anyone else and they're being made available to the applicant. Now, that is not the language that a bank would use. A bank doesn't have any legal or beneficial entitlement to your funds. It's in a position that's analogous to a trustee. So it's not going to be saying that they're making your funds available to you. That just doesn't work. So the third party letter is going to be from, say, another individual or business. Now, that could be from your business, but if it's just in a bank, if you're only relying on 50k plus that's in your bank account, but it's been in there for less than 3 months, then it would be easier for a third party to have those funds and confirm they're making them available to you, because in that case there's no requirement for them being held for 3 months, than asking a bank, your own bank, to confirm the funds are being made available to you. So I think you've probably got 2 options if you've had the funds but you've had them for less than 3 months. One is to simply wait for the remainder of the time. Now, if you are getting endorsed, remember, if you get the endorsement letter, you've still got 3 months before you actually have to make your visa application. So if you've had the funds, say, I don't know, 2 weeks or a month before you've started the process for getting an endorsement, then you've still got a healthy lead-in period. Now, the other important point I want to make here is that remember that you can bypass all of these 4 methods from one perspective if the endorsing body actually confirms that the funds are available. But in my view, the endorsing body should not be applying a lesser evidential standard than the Home Office itself for assessing whether the funds are available. So I don't think that the endorsing body should be accepting evidence, for example, from a foreign bank where they don't have the declaration from the legal advisor to confirm the authenticity of the signature, for example. It would be odd if there was a discrepancy between evidential standards, depending on whether you are proving it to the Home Office or you are proving it to the endorsing body. So I think the best and right approach is for endorsing bodies to apply exactly the same standards. So although you can bypass this from one perspective, in another sense you can't, in that you've got to provide the same evidential standards. My point is that you don't need to prove this for necessarily to the Home Office as an audience if the endorsing body itself can just provide a confirmation, but the evidence underlying that must be exactly the same. So let's go on to the last way of showing that the funds are available. So we finished that diagram. So number 4, if they've already been invested. Now, I would not recommend investing the funds before you speak to a lawyer. If you do want to speak to me, by the way, I have a free consultation service. I'm a UK-based lawyer, and I would be delighted to help you with your application. Essentially, the reason why I think you shouldn't invest or take any major steps for that matter before speaking to an advisor is that, for example, on this point for investment, if you set up a new co in the UK and invest into it, and it turns out you want to apply for the startup visa, then you could actually disqualify yourself if that company has begun trading, or on one reading not, because you've established a UK business. It's best not to incorporate before you've taken advice on this procedure. It's only if you're definitely going for the Innovator route that you can invest already, because then you're permitted under the Innovator rules to have a business already established, but not, you can, under the startup rules, you can actually disqualify yourself. So if you have already invested, then you should already have taken legal advice. So let's see what the rules provide. So if any of the funds have already been invested in the applicant's business, the applicant must provide either of the following evidence showing the amount that's been invested. So business accounts showing the name of the accountant and the date that they were produced. And it's as simple as that. So look, you've got this diagram. I'm going to provide this diagram and the different constituent elements of it and some notes in a blog post, which I'll be doing and linking below. So feel free to check that out. I'll also be doing a series of other videos about how to satisfy the other requirements. Feel free to subscribe and click the notification bell to get those videos. And feel free to contact me for a free consultation if you need help with the process of applying for an Innovator visa or startup visa, or if you're just considering your international options for residency and citizenship by investment, and also entrepreneur and startup visas. Many thanks for your time, and I'll see you in the next live stream.